Okay, everyone, I promised you that I would do a video on the recent Dobbs case and what it means, how did we get here, what the court actually said, so that you have an understanding of what all of this means. All right, so this whole case started when the state of Mississippi passed a law that said that a woman could not get an abortion after the 15th week of pregnancy unless there was a medical emergency or there was a severe fetal abnormality. Jackson Women's Health Organization, an abortion clinic, was like, whoa, bro, that's actually unconstitutional. Under Roe v. Wade and Casey, you can't do that. So then they fought about it at the lower courts, and then eventually it made its way up to the Supreme Court. All right, I think it's helpful to just sort of go over government at a very high level. We have legislative branch, which is Congress and the Senate. We have the executive branch, which is like the president and VP and federal agencies. And then we have the judicial system. And each of them is responsible for different things. The legislative branch makes laws. The executive branch carries out the laws. And the judicial branch is responsible for evaluating the laws. A judge's job is always to look at the facts of the case as it applies to the law and then make a decision based on their evaluation of the law. In the Dobbs case, these peeps down here, their job was to look at the Constitution, the law, and say, does a woman have a right under the Constitution to an abortion? Did the Roe courts and the Casey courts get it right or get it wrong? The Constitution is the supreme law of the land, which means it applies to all 50 states. So if the Constitution says either explicitly or implicitly that a woman has a right to an abortion, then that applies to the entire nation. If it doesn't say that, then the states have the ability to regulate abortion within their state. It's pretty clear that there's nothing in the Constitution that explicitly and specifically says that a woman has a right to an abortion. So it's not like the drafters were like, hear ye, a woman shall have the right to an abortion. Yeah, write that down. So since there's not an explicit right to an abortion in the Constitution, the courts have to look at whether there is an implicit right or an unenumerated right to an abortion. Say that 5 times fast. Okay, so in Roe versus Wade in 1973, the court said, we know that there's not an explicit right in the Constitution. We think that there is an implicit right, and that is the right to privacy under the Due Process Clause of the 14th Amendment. Therefore, states cannot regulate abortion before viability, which is between 24 and 28 weeks after conception. So then in 1992, the Supreme Court heard the Casey case, which upheld the central ruling in Roe versus Wade. However, they were like, we don't really like what Roe versus Wade said in terms of like the right to privacy, but under this doctrine of stare decisis, we're going to respect their precedent, respect their opinion. We're going to uphold their central ruling, but we think that actually a woman has a right to an abortion under the Liberty Clause in the 14th Amendment. Okay, so back to Dobbs. The majority opinion of the court was that Roe and Casey actually got it wrong, and that their evaluation of the law was wrong, and that we don't think that there is an implicit right to abortion via the Constitution. When you're looking at whether there is an unenumerated right or a right that is not mentioned in the Constitution, you have to ask 2 questions. Is it deeply rooted in this nation's history and tradition, and is it implicit in the concept of ordered liberty? So the Dobbs court said that the right to abortion is not deeply rooted in our nation's history because since the 1800s and up until 1973, abortion was regulated or criminalized in some way. And at the time the 14th Amendment was adopted, 3/4 of the states had actually criminalized abortion. So presumably, if they intended to give a woman a right to abortion, they would have written it down. So Justice Alito, the author of the majority opinion, said, okay, looking at the term liberty is a capacious term. It's a really, really broad term, and it means something different to everybody. And then he says, since the term liberty can be interpreted differently by different people, the voters should decide within their own state how they want to handle abortion, because they might view abortion differently in terms of liberty than another state. So then the court looked at whether there was this broader sort of entrenched right to abortion. And the court said, no, we're not buying that, because if we open that door, we're talking about human life. If we open that door, then we could open the door to things like illicit drug use and prostitution. Here we're talking about human life, so we're not buying that argument. And finally, they looked at the doctrine of stare decisis, which basically says that we have to respect prior courts before us. We should generally uphold their decisions. They've gone through the process of evaluating the case, and generally speaking, we should respect their decisions and uphold their precedent. However, this doctrine is not absolute. And so when we're looking at cases that involve constitutional questions, we really need to evaluate whether the prior court got it right or got it wrong. So the court gave a very well-known example, Brown versus Board of Education, which overruled the Plessy case. The Plessy case said that racial segregation was constitutional, and Brown versus Board of Education was like, no, it's not. Justice Alito addressed the concern that overruling Roe and Casey would put other rights in jeopardy, and Justice Alito said that this decision concerns the constitutional right to abortion and no other right, and nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Ultimately, the court held, hey, we're out of it. This is not our jam. This is not for us to decide. So we're going to put the decision making back to the voters and to their elected representatives so that they can decide whether they want to regulate abortion or not. It's a highly charged moral issue, and it's not for us to decide, but for the voters to decide. So that is a very high-level look at this case. Obviously, there are way more details. The court gets into very specific arguments in its opinion. The majority opinion is somewhere around 80 pages. I know that it takes a lot of time to read, but I would really encourage people to read the majority opinion. I haven't gotten to the dissenting opinions yet, but I will do that. I will read those opinions, and then I will do a follow-up video on what the concurring and dissenting opinions say. At a minimum, I would encourage people to read the summary of the majority opinion. You can find it online. All you have to do is just Google the Dobbs case. It is public record, obviously. So there's an 8-page summary. I would encourage you to at least read that.